In ESL, that was about 5 months more, but they have not considered that. That can be a mistake from the immigration, or they are not considering those ESL non-credit hours? What can be the issue?
Yeah, you have to have a certain number of credited hours for you to qualify for. So there is the work authorization due to economic hardship is given, but you have to be in valid F-1 status holder for at least one academic year, which is 9 months. But for this, you have to be enrolled. Now, obviously, you've done this for on-campus employment, right? And
no. This is off-campus.
Off-campus? Okay.
Off-campus,
right.
yes.
So, and you have been in good academic standing, and you
yes.
are enrolled in a full course load?
Yes.
Okay. All right. And you've also shown that the on-campus employment is either unavailable or insufficient.
Yeah, because I was applying to different sections.
You've gone through all the wrongs of proving that except for the ESL part. So,
yes.
Because I think it's not going towards the course requirements, but it is a precursor to you starting out as a student, the government may have made the decision based on that.
No, but my advisor in the college, she is asking me that you are eligible, because first time when I applied for the work permission, I took advice from my international advisor, and she recommended me that yes, you are eligible and you can go for this. And now immigration didn't even notify anything about those non-credit hours. They just consider that I was enrolled in this current college from 2015 August, and they just objected on this point that I have not fulfilled my one academic year. Should I send an appeal? Because my advisor is advising me to send an appeal on that I am full 1 year, I'm having 1 year academic year of F-1 status. So I just need your advice.
You could definitely try an appeal if it is that the F-1 status that you have for the ESL, English as Second Language, if you have been given credit for that and that is part of your F-1, then you could use that as your reason for an appeal.
Okay. Can I do it from your office if you people address such type of issues?
We do address all kinds of immigration issues, but I'd like to see the government's decision before we say that we'll take it on. So we'll have to just look through it and then decide whether we take that on. But of course, you're most welcome to call.
Okay, I will take an appointment with your office. Thank you very much.
And for your information, 972-361-0606 is the number to take the appointment for personal and private consultation. Going to our next caller, Fun Asia Radio. You are live on the air. Go ahead and ask your question to Pallavi.
Good morning, Pallavi. I have a quick question. I applied for my I-485 back in 2007. And I've been working on EAD, myself and my wife, and every 2 years now I apply for a renewal of my EAD. What happened initially, my EAD would expire in the month of August, by end of August, and they used to take like 3 months to 6 months to approve it. So I used to apply in advance, like 6 months in advance. So this year I applied for my renewal, and they approved my EAD in like 2 weeks, and the renewal date is in February. So I lost 6 months of my EAD time, and I'm paying a lot of money. Like for myself and my wife, I'm paying extra $700. So they are taking away my 6 months worth fees.
This is the EAD eligibility is not like an H-1B. I understand you could not fully utilize the value of what you had put into your fees for the previous EAD because this one started a bit earlier. But this is not, this is given to you on an unlimited basis, right? So besides the point that you're not being able to utilize the previously given one because you have a new one that's for which the approval has already started, there is no other harm because these are interminable, which means that they'll keep you'll keep getting your EADs up until you get your 485 approved and get your green card. So at this point, even just giving it back would not make, there is no recourse to that because you are the one that had applied for it a bit earlier, right? So the government will say, now when we put in a start date, that start date that you had requested for should have been clarified to them that you were looking for a start date from the time that it finishes out, right? So, and maybe that clarification wasn't made, but there is not an option to go return it and for them to issue a new one. That process itself will take you a lot of, it's just going to cost you a lot of time, and you won't have the results that you're looking for. It'll take you about almost 8 to 9 months to just resolve this with the government. It's not just worth it. So I would just say just continue with this EAD as long as it's valid and it's giving you employment authorization. Be aware that the government can process it within a few weeks to 90 days currently, and then later on, I believe the law is going to change where we have an update from the government end of December, where once that EAD is filed and you've had it approved once, you apply for an extension. Even if the extension is pending, you can work based on that extension. So that is a regulation that's still under process and it's still underway. It's not still been decided, or the comment period is just recently over end of February. So we'll have to wait for an update and the new regulation to be posted. So for right now, all I can say is, you have an EAD, just use it, just work. It may not be worth your time to resolve it.
All right. Thank you so much.
All the best.
Thank you for your call. 972-235-5555 is the number in the studio to get in touch with Pallavi right now. You're live on the air. Go ahead and ask your question to Pallavi, please.
Hi, Pallavi. I have a question for you.
Go ahead, please.
H-1B visa.
Yes, go ahead.
I'm on an H-1B visa and I was let go from my company last week. So the question I have is, how much time do I have to find another job and still be with this
So from the time that the job ends, you are almost immediately out of status. However, that happens immediately or is known to the government when your employer withdraws your H-1B application. So upon a layoff or a termination, the employer is supposed to inform the government that this employee is no longer with us. So if that has happened, then you would not have status currently, and you may look for a job, but the next kind of process that you would go through would be a counselor processing of the H-1B. So when you move to another employer. Now, if the employer has still not withdrawn your H-1B, then whatever your pay cycle is, if your pay cycle is every 2 weeks, then the discovery on the last paycheck is going to happen in 2 weeks from the time that you were let go, right? And if it is on a monthly cycle, then you would have the employer, if your next check will not be due for another month, then you have it in that month to be able to transfer. And that's only if the employer has not withdrawn your H-1B yet. Most employers, upon termination or a layoff, do send out a note to the government saying that this person or this case number is no longer with us.
So I'm pretty sure that the employer has not withdrawn the H-1B visa. So I was planning to find a job and transfer my H-1B to another company or a consultant.
Yeah, so I would say as soon as possible. And again, if you have your pay slip, which is not current, then you're going to have trouble with the government asking you for a maintenance of status proof, and the fact that you didn't have your pay stub that was recent will ask them or will make them give you an approval, a 797 without an I-94, which means that you'll have to step out of the country and come back in. So we start people off by saying, once you're filing a case like that, do it counselor processing. Use the contiguous territory rule, which means that you can step out to Mexico or to Canada or one of the Caribbean islands. There are some territories that are considered to be contiguous, and those, if you step out and re-enter, you can come in with your 797 and CBP will give you an I-94 when you enter the country without a visa.
Okay.
All right?
All right. Thank you so much for your call. 972-235-5555 number in the studio. For the listeners who are tuning in just now, this is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. To get in touch with her, you do need to take an appointment. Call them at 972-361-0606. Ahluwalialaw.com is their website. Going to our next caller. Fun Asia Radio, you are live on the air. Please ask your question to Pallavi.
Hello, ladies. I wanted to ask about filing a permanent residency for my parents. They are in India right now. I'm a U.S. citizen. Now, I have heard that it's fast. The process is faster if I get them over here. They are here, and then I file for the permanent residency versus when they are right now the way they are back in India. Is that true?
No, the opposite is true. The consular processing currently is moving a bit faster. It's working where people get their green card under a year. Now, one thing to understand is if people are coming into the country on a visitor visa, they cannot file for a change of status or an adjustment of status for 2 to 3 months from the time they enter. And then after they've applied for the permanent residency, then it will take about 3 to 4 months for them to be eligible to be able to travel back in case they have a trip planned back to the home country. So that means they'll get their EAD and their combo card, which also has the re-entry permit in it or the advance parole in it, and that's what they'll get only 4 months. So that's 7 months into the process or upon their entry. And after that, they'll take another, I'd like to say about 8 months or so to be able to get that green card going. We see parents taking a good 13 to 14 months inside the country, any immediate relative, whether it's a parent or a spouse, and it's just a bit under a year if you're going consular processing.
Also, it's better if they are right now in India and have filed for the permanent residency, you said?
Yes, so it would go through a 2-step or actually a 3-step process. The first step being a petition for your relative in the country. Upon its approval, it moves to the National Visa Center. Once the National Visa Center is satisfied with the documents, that's when they move to the 3rd step, which is the interview and medicals back in the home country. So this process, as we are timing it right now within our office, seems to be finishing up a bit faster than what we're seeing in the adjustment of status. The only comfort on the adjustment of status would be that your parents would be here, and while they await their green card, they just have to be patient, and that may take 13 to 15 months.
Oh, so but if it's an adjustment of status, which I think I was planning earlier, they don't have to leave the country because a visitor visa is going to be for 6 months at a time. So if they get here and I apply for them for adjustment of status, they don't have to leave?
Yeah, the visitor visa becomes invalid once you have an adjustment of status that is applied on top. It has no value anymore.
So they have to leave?
No, they don't have to leave. Once an adjustment is applied for, they cannot leave until they have the work permit as well as the advance parole, which is a combo card that I was talking about.
I got you. Okay. That'll work. Thank you so much.
All right. Thank you for your call. 972-235-5555. Number in the studio. Going to our next caller. Fun Asia Radio, you are live on the air. Go ahead and ask your question, please.
Hi, Pallavi. My employer has is going to put in an application for me to process for green card under EB1 category. And my L1 visa is coming up for expiry in about 5 months from now. And from what I understand, there is some internal processing that will take at least 2 or 3 months before the filing actually happens. So under that circumstance, should I be applying for extension to my L1 visa in the meanwhile?
Yeah, absolutely. So the EB1 petition itself, which is the EB1C, or multinational executive or manager, takes about 8-9 months to get approved for the I-140. Now, if unless the employer is planning on doing this as a concurrent filing, which means that they are filing the I-140 along with the 485, you will have to extend that L1. The EB1C is a tough category currently, and it is prone to a lot of RFEs and major audits, and there are some certain sensitivities that the government is showing its proclivity for, and that's the reason the application has to be well planned. I don't understand the reason about a 2 to 3 month wait. However, maybe that is their internal process, or that's how long it takes for the file to leave within the office. I would definitely say if you have an option for an L1A extension, by all means, just go ahead and apply for that and leave that pending, because that leaves you in a solid non-immigrant status, as opposed to having just an adjustment of status that's pending for you, and that is filed at the end of your L time.
So they are filing concurrently. In fact, I've given them all the paperwork, but it's some internal processing time that they have that will take a couple of months. And I'm told that it can take about 8 or 9 months for the process to complete with the immigration authorities.
Yeah, I would not let go of the underlying visa.
Okay.
Or the status. I would extend that L1 and keep that going, because, like I said, the EB1C is a tougher category, and the company just has to understand the kind of documents that are required and what the focus of the government is currently. I'm sure they're doing a lot of these, and to make sure that it does get approved in the first shot.
Okay, thank you.
All right, thank you for your call. We have some 3 minutes left on the clock. Let's squeeze in one quick call there. Fun Asia Radio, you're live on the air. Please go ahead and ask your question very quickly. We have very little time left.
Okay, I had the question where I was looking to sponsor a green card for my dad, and he doesn't currently, because in old days they don't have he doesn't have his birth certificate and marriage certificate. So how can we get those documents, legal documents, to apply for green card? Okay, so the only way that the government is going to accept secondary documents for birth proof would be to get a non-availability certificate from the municipality or the city where he was born or where he belongs to. So a government authority on their letterhead has to be able to say that there is no birth certificate available for that person, and they've looked through their records. That's what's required. Now, with that, the government will accept any other proof that shows that that's a birth date, a 10th grade certificate, anything that has some bank records, some Indian government records, not a passport, but anything else that shows that birth date would be acceptable. So like the birth certificate, the 10th grade certificate does not require to be as an affidavit. We don't have to get it notarized. It's just that certificate would be good enough along with the non-availability certificate. Yeah, that, and then look for one more proof of secondary evidence. If there's any PAN card, the PAN card, if that had a birth date, yes, that would work. Just the same will apply for the marriage certificate too. Like it doesn't even. Yeah, I mean the non-availability certificate. Usually, I mean you could check for that also, and then you could have an older relative that can attest to the fact that they were married, and then just see if there were any other documents that show them as husband and wife. Okay, like bank account or something like that will do. Yes, but okay. You also will still need that non-availability. Okay, so non-availability for both marriage and birth certificate is needed. Along with that, I can submit the secondary documents. Correct. Okay, thank you so much.
Thank you so much for your call. And that's about it, Pallavi. And yes, thank you for all your calls, people. And any final quick words, Pallavi, for our listeners here?
Well, I wanted to wish everybody the best for the H-1B lottery. I know we have a lot of people that are participating, especially a lot of students that are now filing for the H-1B. Since this is just a lottery, we just have to say, may the luck be with you when you get selected in the lottery. Lots of cases are going to be leaving our office tomorrow as well. And we wish everybody out there good luck in that lottery.
Thank you so much, Pallavi, and talk to you next Wednesday. Thank you.
Thank you, Mitu. Bye-bye.
Bye.
This has been your weekly show, Your Business Matters with Attorney